I think we might be all right to start now, Rosie, because I
I
think
just
it's
needed a verification to be able to log into the YouTube account. It's the
oh
info at Generation Rent on a Galaxy S9.
oh okay. That might be Dan's phone. Um,
Try another way. Sorry. Could we just,
yeah, we. I think he's recording at the moment, so we can always just say to people that he's recording, and we can upload it later.
is that okay? I'm so
Yeah, yeah,
sorry.
no, it's fine, it's fine.
Okay.
Don't worry about
Thank
it.
you. I just, yeah, it needs a verification. Has it? Hi there. We'll just wait for, sorry that we're a bit late on getting started. We are ready to go now. I just wanted to introduce myself. I'm Rosie. I'm here from a campaign officer at Generation Rent. And here we have Simon Mullings joining us today, who we are very honoured to have with us, a great housing lawyer, and will be sharing his knowledge on evictions. So just so everyone knows, the session will be recorded. And there will be about a 20-minute long presentation before the opportunity to come in and ask any questions that you may have, which if you could please share them in the Q&A, and we'll come through to them at the end. So yeah, thank you so much, and I will hand over to you, Simon.
Brilliant. Thank you very much, Rosie. Hello, everybody. Very nice to see you, and it's a great privilege to be asked to come and speak to you this evening on the topic of evictions. I'm going to speak in a fairly free form way, and I'm very much more interested in your questions and seeing what we can all do together to answer whatever questions we may have. So. I will bash through a little presentation, but I'm very much looking forward to seeing what questions we got. So do think about those as we're going through, and you know, you might want to think about very specific questions. That's great. Let's put our heads together and see if we can answer those. You might have wider questions, particularly in the current situation where we have the Renters Reform Act supposed to be going through Parliament, and I might have a little bit to say about that towards the end. But you may have questions about that. You may have observations to make, and it will be really good to hear from you. So, what I want to do, I think, is concentrate, because we've got the Renters Reform Bill in. I think I want to concentrate on Section 21 and the way in which landlords can seek to get possession of properties through that mechanism. And then as we look at that, because, well, news today lets us know that there's probably going to be yet a further delay on the Renters Reform Bill. And as I say, I'll come to something about that later. But it's certainly the case, you know, Section 21 as a means of taking possession is still available to landlords, still will be for some time. And of course, as actually proper renters reform and the Act comes closer, it may well be that landlords start well, they kind of already have started a sort of you know, preemptive pile-on in terms of Section 21 claims, I'm afraid, and we're seeing many more of them through the courts. So let's have a little gallop through history. And let me take you back to 1988. Some of you may not even have been born then, which is a frightening thing for me to say. But in 1988, a Housing Act was brought forward by government, came into force in early 1989, and it had a profound effect on the private rented sector because it introduced Section 21 of the Housing Act 1988. And it introduced at that point what we now call no fault eviction. So it meant that landlords for new tenancies from, I think it's January 27th, 1989. But anyway, from that point on, landlords could use Section 21 to say, okay, well, the fixed term of your tenancy has come to an end. I'm giving you 2 months notice. I don't have any particular reason. I don't have to give any reason. I'm just giving you this notice. And then at the end of that, if I take it to court, the judge will have to make an order for possession. So that's where all of this started. Prior to that date, it wasn't possible for landlords to do that. They would have to have a reason for bringing possession proceedings. But I'm not going to go back in detail over the Rent Acts because they're very complicated and they're very, very ancient pieces of law now. So the next big development. So from 1989, landlords could use Section 21 for assured short hold tenancies. There then comes a shift in 1996 with the Housing Act 1996. Again, comes into force early in the year after, so in 1997. And what that act did, this is at the back end of the last long-standing Conservative government, and who knows, we might be at the back end of a long-standing Conservative government now. Who could know what's going to happen with that? But so towards the back end of that government, the 1996 Housing Act is brought forward, comes into force in January. February 1997. And that meant that virtually all kinds of private rented accommodation were assured short hold tenancies. Prior to that act, you had to do a special thing. You had to, when you entered in as a landlord, when you entered into a private rented tenancy, you had to give a special notice to the tenant to say that this was going to be assured short hold. From 1997, it was precisely the other way round. If you just signed a tenancy agreement with a tenant, it was an assured short hold tenancy, unless you gave a special notice to say it was going to be assured. So that meant that Section 21 notices and this no fault eviction process was then usable by landlords in, all new private rented tenancies. So for all new private rents, then Section 21 was available. And so it's become obviously an extremely powerful force for landlords to regain possession from tenants at their will, and without having to give any reasons. And that's why we call it no fault eviction. No fault eviction, though, is it's not that it's inaccurate, but it's sometimes not a helpful phrase, because landlords will sometimes use Section 21 when they perceive, they'll sometimes use it instead of using rent arrears grounds to get possession, because it certainly was thought to be easier. And it was a mandatory ground for possession. The judge had to make an order. And also landlords had their own reasons. There is generally always a reason, obviously, seeking possession. And while there might not be fault, it's certainly a reason. I find the no fault kind of term, I know why it's used, but I find it a bit problematic. And that doesn't matter too much. So how does it work? It works, at its simplest, it works in that if the fixed term of a private tenancy has come to an end and a new fixed term hasn't started, then the landlord can take a Section 21 notice case to court and ask the judge to make a possession order. And as we've already said, they don't need to give a reason. The judge will not ask them a reason. They don't have to give a reason. The judge is simply concerned with whether the Section 21 notice has been properly served and whether it is valid to end the tenancy or not. Now, that's when it does start to become complicated, and it has become more complicated over the years. Now, I'm not going to do a history lesson on amendments to the Housing Act because it does get very, there's lots of what I call encumbrances now upon Section 21 that's actually made it much more difficult for landlords to reliably use Section 21. Mostly, governments have loaded, how can I put it, obligations that landlords have in relation to, safety within the property. They've loaded that as a precondition of being able to use a Section 21 notice. And I'll give some examples in a minute. But there's other conditions as well. So if there's a tenancy deposit that's been taken, the landlord has to have done that properly before they can serve a valid Section 21 notice. The government became concerned about unlawful fees, or, well, they weren't unlawful at that time, but agents or landlords just charging random fees to tenants, at the time of their tenancy or even through tenancies. So the government then made it not possible to serve a valid Section 21 notice if the landlord had charged certain unlawful fees of the tenant. And again, we'll talk a little bit more about that in a moment. So what started out as a relatively simple procedure, a relatively simple procedure of serving a notice, giving in a proper form, giving 2 months' notice to the tenant that the landlord wanted the property back, has become much more complicated over the years as government has added more amending legislation and other legislation to set a precondition for serving a valid Section 21 notice. So let's start to look through some of the conditions that exist. Firstly, we've already mentioned one, giving 2 months' notice. A landlord's Section 21 notice must give 2 clear months. If it doesn't, then it is not a valid Section 21 notice. And just recently, I had quite quite an amusing case where a landlord had served a Section 21 notice, but there was a postal strike, and they had their solicitors had put it in the post on one day, and normally you'd expect it to have arrived in the first class post on the second day after that. So I think it was put in the post on a Wednesday. You'd expected it to arrive on a Friday. But it didn't, because there was a postal strike. It didn't actually arrive till the next Tuesday. That meant that the notice given to the tenant was less than 2 months. When you calculated between the date it was received and the date that the tenant was given for when possession was required, was less than 2 months. We had a bit of a back and forth in court about that, but the judge eventually agreed with us that the landlord couldn't rely on what's called deemed service provisions. I won't go into any detail about that. This is just one of my little war stories that I like to tell. But the judge agreed with us that in the absence of anything written down in the tenancy agreement, it was the date that the notice was actually received by the tenant, and the tenant had given good evidence that they didn't get it until this later date. So the landlord could not have possession of the property, and they're going to have to start again with that. So it's they cut it fine. To be fair, I mean most landlords will allow perhaps an extra week because so they'll do 2 months in a week because things can go wrong with service of the notice. But this landlord didn't do that. So it's got to be 2 months, and it's got to expire. I mean, there are more complicated rules now, but in the olden days, it was that it had to expire on or after the ending of a fixed term. So if it expired within a fixed term, then that couldn't be valid because the fixed term was still ongoing. There are now more complicated rules that about not only when the notice expires, but also when it's served. And also there are rules about the period of time that's elapsed since the date that the notice expires and the landlord bringing proceedings. We call that use it or lose it provisions. But you have to have brought proceedings within a certain period of time. And if a landlord doesn't do that, again, the notice can be invalid. I can't actually remember the period of time that it is, shamefully. Maybe somebody knows and can put it in the chat, but I can't remember the time that you've got from the notice expiring to actually bringing proceedings. As I go through these, it becomes clear that I can't hold all of this in my head. It really is quite complicated. So whenever I get a case of Section 21, I have to look every single one of these points up because you cannot hold it all in your head. It's quite complicated. So that's to do with timing of the notice and the fixed term. So what other conditions are there? Well, actually, the Section 21 notice did not used to be in the prescribed form, but it did have prescribed information. That's changed, and now there is a prescribed form, and if the landlord doesn't use that prescribed form, then again, it may be that the notice is invalid. There is a bit of wriggle room with that, but generally, the landlord has to use the prescribed form. So a letter which sort of, says some stuff about leaving after 2 months, no, that won't cut it because it has to be on the prescribed form. We talked then we mentioned the tenants' fees, and under the Tenants' Fees Act, there are a number of fees that landlords or letting agents, if they charge those fees, then those are unlawful fees, and they will invalidate a Section 21 notice. So a tenant who has been charged one of these unlawful fees can use that as a defence to possession proceedings brought by the landlord. Again, I can't list those fees for you. There's a number of them, and some of them are even quite complicated to work out because a multiple of the tenancy deposit can be an unlawful fee. So you have to look at the formula and work out whether the deposit is too much over the threshold for it to be lawful or not. So there's things like that. So that's another thing that I have to look up every time. What next? It's always difficult to know which order to take these in, but I don't suppose it really matters. If a property is required to be licensed with the local authority, and in general, we're talking about HMO licensing, house in multiple occupation licensing, and in other cases, we're talking about selective licensing. So, sorry, HMO licensing is comprehensive throughout England and Wales. If it's an HMO, it has to be. Actually, I'm not going to say about Wales, just in case I get that wrong. I think it applies in Wales, but I'm not an expert in Welsh law, and Welsh law is increasingly diverging from English law, so I'm going to be careful about that. Let's say English law. An HMO is an HMO, and it's required to be licensed. So that's a mandatory license. A house in multiple occupation, at its simplest, I think it's 5 people living in 2 or more households in one building, basically, and sharing facilities. Again, it's a definition that sometimes you have to go and check. But such a property has to be licensed with the local authority by the landlord or the agent. In selective licensing cases, that's where a local authority has elected to run a licensing scheme, and that can be across the whole borough, or it can be in certain wards within a borough. What the borough can say is, well, if you're a landlord renting property in this ward or in this borough, you have to get a license, whether it's an HMO or not. So that's the next thing that you have to check. and local authorities publish details of their licensing schemes. So if it's a borough you're not familiar with, you might have to actually go to that borough's website and find out if the property that, in my case, if my client comes to me, I sometimes have to go and have a look and see whether that client lives in a selected license area or not. If it's not licensed, the landlord cannot serve a valid Section 21 notice. So that's license. So we've done tenants' fees, we've done licensing. Help me, Rosie, just in case if I start talking about one I've already talked about, just do that or something.
No, you haven't. Thank you.
Next, let's start talking about government how to rent leaflets. So since I think it's 2015, landlords have had to provide tenants with a how to rent leaflet, and this is a government produced leaflet. There's been various editions, and the landlord has to have provided the correct edition at the correct time. So if they gave the tenant an out-of-date leaflet, they haven't complied with that requirement. So if that requirement has not been met, the landlord can't serve a valid Section 21 notice. Energy performance certificates from around about the same time. Landlords have had to provide energy performance certificates. They're quite baffling documents, actually, but they have to provide them. And if a landlord has not provided that to the tenant, then the landlord cannot serve a valid Section 21 notice. Gas safe certificates. Now, this is really complicated, but basically, a landlord since 2015 has had to serve a valid gas safe certificate to the prospective tenant before they take up occupation. Otherwise, they can't serve a valid Section 21 notice. And they must also, so the law requires them to serve a valid gas safe certificate once every year, annually. Now, if they miss out a number of years, but then serve a valid gas safe certificate and then serve a Section 21 notice, they've still broken the law in relation to gas safety regulations, but they're allowed to serve their Section 21 notice. They've made good the fact that they failed to serve a gas safe certificate before. Okay, so a landlord can comply late with the obligation to serve a gas safe certificate and then serve a valid Section 21 notice. The exception to that is the gas safe certificate that they must give to a prospective occupant before they take up occupation. That's a misunderstood point of law, and it's not just lawyers that misunderstand it, it's judges as well. Mainly because the case law on this is confusing and unhelpful. But it is certainly the case, well, there's certainly persuasive authority at county court level that if a landlord doesn't serve a gas safe certificate prior to occupation, they can never, and they have no way of making that good, they can never serve a valid Section 21 notice. Now, that's quite a startling thing because there's a case that seems to suggest that that's not the case, but it's more complicated than that. Anybody with gas safe, they should see a lawyer. If they think there's a gas safe issue, they should definitely see a lawyer. What else do we have? Housing conditions. So the other thing that can invalidate a Section 21 notice is if the local authority has, so it's called sometimes retaliatory eviction. But again, I'm not sure that this is a super helpful term because landlords can bring retaliatory evictions in all sorts of different ways. And there's not a lot that a tenant can do about it. But if a tenant has, and I'm going to try and get all the components of this right, but I would always go and look it up in defending possession proceedings or another book, just because it's so complicated. But if a tenant has complained to their landlord about serious disrepair in their home, and nothing is done, and a local authority then serves one of two kinds of notices. One is a prohibition notice, And the other, I think, is called an improvement notice. These are notices prescribed, I believe it's under the 2004 Housing Act. But if one of those notices is served, if the landlord then subsequently brings serve the Section 21 notice again, that Section 21 notice will not be valid, and the tenant will have a full defence to those proceedings. Right, I'm going to speed up now because I've already taken up quite a bit of time. I think I've covered all the defences. If I've missed any, you will tell me, and I'd be very happy to be told that I have I've missed one. So thank you very much for anybody who puts in the chat that I've missed one. Really, please do, because everybody needs to know. What I think it's important for me to say now is that there are two ways in which a Section 21 case can come before the court, and the one that I'm most concerned about is the accelerated possession. It's called the accelerated possession procedure, because with this procedure, a landlord puts together a raft of paperwork, including a court claim form, and then all the documents that the landlord will rely upon to try and persuade the judge to make a possession order. And that includes the tenancy agreement, any replacement tenancy agreement, the Section 21 notice, and then all the documents required to prove energy performance certificate, gas safe certificate, how to rent leaflet. All of that documentation is supposed to be exhibited. Now, what happens is the landlord puts that documentation into the court. The court gives it a claim number, issues the claim, takes the court fee, from the landlord, and then sends it to the defendant, sends a copy of the whole thing to the defendant with a defence form. And the claim, and what the court is supposed to do is on the front of that court form, that claim form, it is supposed to write the date by which the tenant defendant must respond to the claim, i.e. put their defence form into the court. My local court often doesn't do that, and believe me, I've had words with them about it, because it's a sad state of affairs, really. This is, it's a very important information, because if time goes by and the tenant doesn't respond, what happens is sometime after 14 days from the date that the tenant is deemed to have been served with these documents, all the papers, including any response from the tenant, but if there's no response from the tenant, it doesn't matter, all the papers will then be handed to a district judge sitting in court or at home in chambers or whatever. So it's literally the papers are passed to them, and the judge will go through those papers and decide whether a possession order will be made. And if everything is in order and the judge can't find a reason why a possession order should not be made, the judge will make that possession order there and then. So you can see how important it is that a tenant responds to that claim in a timely way, because otherwise the claim just goes through on what the landlord says. And, some landlords are unscrupulous and will say whatever they want to get possession. Lots of landlords, it has to be said, are not unscrupulous, but may not know may not know the law, and they're certainly not going to go, oh, I'm not really sure if I should have possession, but anyway, I'd love it if you would please give me a possession. They've just basically, if a tenant wants to be heard on this question of whether they will have to give up their home, it's so important that they get that defence form in. And I want to highlight a new service that's been launched by the Legal Aid Agency. You don't often hear me praising the Legal Aid Agency, but I'm going to right now, because they've launched a new service where anybody who's had a notice of possession proceedings, regardless of their income, they don't have to be financially eligible, but they can seek legal advice from a contracted legal aid supplier of early legal advice. And the information about that should be available from your local kind of advice centres as to who can give you that advice. But it also would come through with the court papers as well. So you'd have another opportunity then to see whether you could get some legal advice on that. There is a problem with capacity because there's not enough legal aid lawyers like me out there, sadly. But it is a really amazing new service from the Legal Aid Agency. Again, asking your local advice centre, Citizens Advice will have information about it if you need that. So do go for that. I wonder actually. I wonder whether we could just do a little search actually for HLPAS and find the government website, because it might be worth putting the link there in the chat, because it is quite helpful information. Sorry, I should have flagged that up before, Rosie. But
no, of course, I'll get that. I'll get that in the chat now.
That's great. Thanks very much indeed. Accelerated possession claim, it is very important to go through the paperwork, hopefully get advice, but if not, go through the paperwork, fill it in. It's not actually hard to fill in the defence form, because it's quite a tick box exercise of saying, did you get this kind of document? Did you get this gas safe certificate? And if you didn't get it, or you're unsure, or you think there's a point to be made, you can tick, no, I didn't get it. What will happen then is that if the judge has any reason to think that, I said before that if the judge didn't have any reason to think that possession order should not be made, they'd make a possession order. If the judge has any reason to believe that there might be a problem with the landlord's paperwork or what's been said here, the judge will then list a hearing, and then the parties will turn up to court, and the judge will hear from both from the landlord and from the tenant and try and work out what's happened and whether a possession order should be made. So then the tenant should get a fair hearing as to whether the landlord has done everything that they're supposed to do in order to serve a valid Section 21 notice. So that's the accelerated claim. Now, the landlord can bring a Section 21 claim in the ordinary. Thanks, Rosie. That's great. Yeah, so that's up in the chat there for you now. The landlord can bring an ordinary claim where there will just be a hearing. So again, and it's really important to go to these hearings, because there's a lot that a landlord can get wrong. And in terms of, trying to protect your home, it's worth going along to see, if you are going to be evicted, you'd at least, I think, want to know that everything had been done properly. But, it would be your opportunity to dispute anything that the landlord's saying on that. So this is important now. So this I think goes to, oh, sorry, just one last thing. A landlord can also bring two claims at the same time in the same claim. So two claims in one, if you like. So if they're claiming rent arrears, they might serve you a notice about rent arrears, but also serve a Section 21 notice as a sort of belt and braces approach. It does mean they have to wait a little bit longer before they can start the proceedings, but they can go to the court and say, well, Judge, they're in rent arrears, but even if you don't think they should be evicted for that reason, I've served the Section 21 notice, so they've got to be evicted anyway. So it's sort of bring the two things together. So again, I mean, it's always important, if you can, to get legal advice whenever you can on these issues. Hopefully what I've outlined today is that they are complicated, and there are things that tenants can say. There are defences, and particularly on Section 21, it's very, very complicated, and landlords often don't understand the rules completely, and so there is a chance with every claim that there may be some form of defence. So, however, if everything is in order, I just want to reiterate that the judge has to make a possession order. There is no question, sadly, of looking at the tenant's circumstances, and that's the wickedness of Section 21. No circumstances of any kind will prevent a possession order being made under Section 21 in the case of a private landlord, where that landlord has got all the paperwork correct. And that's a tragedy for many, many people, and it's why the Renters Reform Act is so important. Now, the Renters Reform Act was introduced in the Theresa May government. I mean, that's how long ago it is. And you may have, it nearly fell away as an act because there didn't appear to be parliamentary time in this particular autumn parliament to get it debated. at second reading for the before the King's speech, and that would have meant that it automatically fell away and would have to be introduced again. In fact, we will have a second reading before the King's speech, but the government has just announced today that it will not press ahead with abolishing Section 21 until it's completed. Hang on, I've got the wording here. This is in a response to the Levelling Up Committee. And it says the government will not commence the abolition of Section 21 until stronger possession grounds, well, we knew about that, and a new court process is in place. And what they mean by that is some court reforms to make it quicker for possession cases to go through the courts. Now, you know, we might want to argue against that, but actually, there are significant delays in the court processes that are nothing to do with, you know, that are everything to do with the court service being in a complete mess. You know, to be fair, that does need sorting out. However, this is the government's problem. This is the problem that the government has made over the last decade or so. So it's a bit rich for them to delay their own act while they sort out those problems. But the Renters Reform Bill, as well as doing many things, is the headline issue is about abolishing Section 21, so abolishing this extremely unfair, no-fault eviction procedures where people, families, whatever their circumstances, can be just uprooted in a relatively short period of time and into a market where, you know, finding new accommodation is really, really difficult and sometimes even impossible. It's a massive driver of homelessness, and it is, you know, it is right that Section 21 should be abolished. There's plenty else in the Renters Reform Bill which is terrible, absolutely terrible, and myself and Generation Rent in particular, also the Renters Reform Coalition, will be, you know, fighting on these other elements of the bill that we're unhappy with, but we're all agreed that Section 21 just has to go. I think that's a good note for me to stop waffling on, and I'd be really, really interested to hear what points, what questions, anything really that you want to contribute. It'd be great to hear from you now.
Thank you so much, Simon. That was really interesting, really helpful, very comprehensive. I actually just wanted to, the first question that we have here is whether this information will be sent around afterwards. And so I was wondering whether there is sort of an online resource you can recommend with this, or whether you have some notes or anything that we can share with the attendees today, so that they can review this information.
Yes, I mean, I have to say, in terms of defending or seeing whether you can defend a Section 21 notice or a Section 21 claim, or indeed all sorts of other proceedings, I have to say that the Shelter website is outstanding. It really is good. I can't, for people who are not lawyers, I can't think of a better resource to go to. And you know, you really just need to Google shelter possession, and you know, it'll take you through, it'll guide you through to the bit that you need to get to, and it gives really comprehensive, really clear, much clearer than I was able to give this evening, frankly, but really clear, comprehensive advice about all of those things I've spoken about, the gas safe certificates, you know, the energy bill, all of that stuff is there. So I thoroughly recommend that. If you love flow charts, and who doesn't love a flow chart, you can Google nearly legal Section 21 flow chart. Nearly Legal is the website of a very, very, very talented lawyer called Giles Peaker, who works at Anthony Gold Solicitors. And he has produced this monster flowchart where you go in at the beginning and it's you know, it's a, you know what a flowchart's like, yes, no, yes, no, and it takes you basically through all of those issues that I've spoken about in a yes/no kind of format, and at the end tells you whether you've got a defence or not. Now, the difficulty with it is it's about 13 pages long, and it's almost like a piece of performance art, as to how complicated Section 21 is. But if you don't mind sitting there really carefully and rigorously going through it, again, it will tell you whether you may have a defence to proceedings or not.
Really useful, thank you. I've popped both of those in the chat as well so that people can have a look, note them down, but we'll also be sending out a follow-up email with this information in, so don't worry if you miss it. I think this was actually from Colin, who wrote in the chat Evictions, so I thought I'd just read them out and share them with you, Simon.
Thank you, Rosie.
So Colin has said that eviction is probably the most controversial and problematic of any issues private rented sector tenants face.
Yeah.
From whether an eviction notice is valid to what other laws may have been breached, such as Landlord Tenants Act, retaliation by either landlord or tenant, through to responses to eviction by renter, council, courts, etc., and potential aftermath of eviction notice, the reasons for eviction, new grounds, and updated grounds to be heard, and whether mandatory grounds will be downgraded to discretionary in the second reading of the Renters Reform Bill on the 23rd of October 2023, which is on Monday. So also he's mentioned that last year he asked about what could be done to support police officers sleeping in cars, and reported by the Police Federation. Did anyone happen on that? And also it was discussed that police officers often don't get involved in eviction as they deem it a civil matter, even though there are aspects that make it criminal, such as the Protection from Eviction Act. So just wondering what your thoughts are here from what Colin said.
Colin, all really, really good points. Thank you so much for contributing those. I've got loads of thoughts on those, so I'll try and keep them brief. Though the housing system is massively broken, and the need for the Renters Reform Act is incredibly acute. But in order to get through the Section 21 abolition, the government has felt the need to give landlords a whole raft of new ways of getting possession back. We don't have enough time to go through all of those, but I think at one point I counted something like 9 new mandatory grounds for possession, that are in the Act, and some of them are absurd. In fact, they're absolutely absurd. What are the chances of getting those changed from mandatory to discretionary? Look, I try to be as optimistic as I can, and I talk to as many people as I can to try and get across the absurdity of the situation, but I don't think the chances are great. We have to keep trying, and we will keep trying. Generation Rent, in particular, I know will keep trying, and Generation Rent has that access to people who will, politicians who will be in the debate. So, I know just from conversing with them that they will be pressing for this very hard. There's one particular mandatory ground, which is ground 8A, which is just ridiculous in that you don't even have to be in rent arrears at the time the matter comes before the judge, and the judge would still have to make a possession order, and that just seems wrong to me. wrong because it also gives some false incentives. This is a case where, I'll try and do it briefly. If you are in 2 months rent arrears 3 times in a 3-year period, and let's face it, with the broken benefit system, that can happen. Talk about no fault eviction. That can happen at no fault to a tenant who's reliant on benefits to help with their rent. That can happen really all too easily. Then it seems to me that at the point at which that person gets into rent arrears for the 3rd time, if they know their law, all the incentives are on them to not pay an extra penny in rent, but to actually save that money, because they're not going to get a reference from their landlord. They're going to need to pay a big deposit on their next private rented accommodation. And, that I would like to get the ear of somebody to see whether that can be debated. Whether I'm too late for that, I don't know. But I know that I know those at Generation Rent who are pushing these things are also aware of that issue. So I hope that they will be doing that. Just lastly on the police. Yes, that has been a problem. I've been doing housing law for 25 years, and that's been a problem for the last 25 years at least. The police have little training and little, well, they don't seem to have much appetite for getting involved in what are, criminal acts of unlawful eviction. A friend of mine, Ben Reeve Lewis, runs an organisation called Safer Renting, though, and they do a lot of training for local authorities, but also when they can persuade, local police kind of groups to have them, they go and do training for the police to to let them know what their powers are and what they should be doing in these circumstances. And I think at some point, if the police carry on as they are doing, I suspect they will face some litigation on this because they are not performing their duties. They're often assisting landlords to carry out unlawful evictions. So, I don't think it'll be too long before if they don't, if they don't fuck their ideas up, they will face litigation or some other kind of sanction, from government. They certainly should. They certainly should. I mean, I think it comes from a place of ignorance rather than. I think it often comes from a place of ignorance rather than antipathy. But at the same time, they're not performing the duty that they should be doing. So yeah, that needs looking at. Thanks, Colin. There's some really interesting stuff in there. We could talk all night on that.
Yeah, it's really interesting. It's also when you're talking about the possession grounds there, it's something because I work for both Generation Rent and the Rental Reform Coalition,
Yeah.
and it is something that we are concerned about as the bill is going through to its second reading, and we are doing a lot of work on it. So although, yeah, it's as you say, Simon, it's like because Safer Renting and Generation Rent are both members of the Rental Reform Coalition,
Yeah.
and there's a lot of people trying to fight these mandatory grounds to try and make them discretionary. So
yes, don't let my slight pessimism put anybody off. There are a lot of people fighting this, and we'll continue to fight it because I don't think it's a dead issue once the act is passed. I just don't think we've got a particularly, even though this is the government's act. Well, as I said before, I think they feel they've had to give this to landlords because of the Section 21 thing is so big. And that's not a mad way of thinking. We may well we do disagree with it, but it's not a mad thing to think. But at the same time, the act is not going to do the job of properly reforming the private rented sector unless that's resolved. Issues regarding rent control are resolved and things like that. So I think it's a long-term fight, personally.
yeah, I agree. I agree with you. And actually, I've got a question that's kind of related to that. And I don't know whether maybe in this answer maybe you could explain the difference between mandatory and discretionary for anyone who might not know. Because another question that did come through was whether you could, which you've already touched on, but whether you could expand on how Section 8 will work in the Rental Reform Bill. So yeah, if you could identify those two things, that'd be really helpful. Thank you.
Yes, apologies. I should have dealt with that. There are two types of grounds for possession that are in the Renters Reform Bill. Some of them, actually, you could say the three kinds, but let's stick with two for the moment. One lot of grounds are discretionary, and one lot of grounds are mandatory. Okay, so we've got the titles of them, but what do they mean? Mandatory means that if all the conditions of the ground are made out, the judge has to make an order for possession. The judge doesn't have any discretion. It's the same as Section 21. No discretion. The circumstances of the tenant, however sympathetic, however tragic even, the judge must not take those into account and must make the order for possession. And then the only thing that the judge can do then is postpone the possession order for up to 42 days, but they can't postpone it any longer, and the possession order has to happen. In discretionary cases, the judge has to consider whether, in all the circumstances, it's reasonable for a possession order to be made. So, there may have been some minor rent arrears, but, the tenant is back on track. They're making installment payments to get back on track with the rent. In those circumstances, most, if not all, judges will say, well, it's just not reasonable for a possession order to be made, or it's not reasonable for an outright possession order to be made. So, they might make a conditional order saying, okay, there'll be a possession order, but it won't be enforced. Nothing will happen as long as the tenant continues paying that rent and, bring the arrears down. So those are the two kinds. If I ruled the world, there wouldn't be any mandatory grounds for possession, because why would you have judges? Why have judges if you're not going to give them some discretion in terms of when they make an order or not? Because there are injustices every single day with mandatory possession orders of all kinds, and that's it's as simple as that. It's not a just way of doing things. So that is the concern about the Renters Reform Act, is that it does introduce all these new mandatory grounds for possession. Does that answer that, or do I need to expand any more on the question? In terms of the way in which it works in the Renters Reform Act, as I say, there are these new grounds. So at the moment, I think there. Can't remember how many grounds there are in the current Housing Act 88 Schedule 2 as it's currently formed. There's something about 14 or 15, I think. The reason why I don't know the number is that some of them are like 7 and then 7A and then even 7B or whatever, so you lose count of how many there are. You can't just go to the last one and go, oh, there's 12, it's fine. There will be a lot more. So again, there's an issue about complicated law, which I'm not a massive fan of, even though it keeps me in a job. I'm not a massive fan of it. In terms of people's homes, people should be able to readily understand how the structure around their home, the legal structure works. It's not always possible because it's too much complication. But there will be more grounds for possession, but Section 21 will go. So there won't be any. The landlord will always need a reason and will have to make out that reason. Even with the mandatory grounds, still have to show that all of the conditions are in place.
That's really helpful, thank you. And I think it is a very complicated subject matter, but you are explaining it very accessibly. And so thank you so much for taking the time to do that, because it is a lot of it. I remember when the bill came out and I looked at it and I just thought, oh, I don't understand any of this. It's just
yeah.
So,
it is a lot. And I've got colleagues who are much better at this because they've done a lot more work on it, but it is very, very complicated. You have to do a lot of work of cutting and pasting things to make a fuller picture of what's actually going on. But yeah.
Well, thank you for understanding it and telling us about it. It's very helpful.
It's a privilege. It's a pleasure and a privilege. It really is.
Oh, good. Well, I'm glad, because we have got some more questions just before we end. We are coming to sort of like the end, sort of last couple of questions. So if anyone else has got any more questions that they want to quickly pop in the chat, we can get through to them as well. And so here, KH has asked whether, with tenancies started in 2007, whether it is a requirement to show the gas safety certificate before signing, and whether there is a cut-off date.
It's a really good question, KH, and that is one of those things that I would always look up. I could take a guess at that now, and I'm not going to. I hope you don't mind. I'm not going to take a guess at it because it's. I was serious earlier. I can hold, because I've done this for a long time. I can hold a lot of stuff in my head in a broad sense. But when it gets down to the details and things like that, I will always go and look it up, because I've made assumptions before And then once I've gone to look it up, I've gone, oh no, you got that assumption wrong. So I just make a point of always looking it up. So there is a cut-off point for gas safe certificates, and I'm sorry, I can't remember what it is. If there is a problem with any of these issues, it's really important to get legal advice and get a lawyer who can sit down and, like I would, go to their defending possession proceedings and just make sure that they've tied down every single point.
Brilliant, thank you.
Defending possession proceedings, by the way, is an absolutely, if you don't know, it's a massive text that is just about defending possession proceedings. It's the Bible of what we're talking about, and also council tenancies and all sorts of things. It's yeah, an absolute Bible, but it's a bit much. It's huge. It's an absolutely huge book.
Possible to remember all of it.
Yeah. Yeah.
No, that makes complete sense. Maybe we can save that question for you, KH, and maybe send it in an email afterwards. Some answer. The next question is an anonymous question, and it's someone asking that, saying that, well, acknowledging that it's quite significant that they won't abolish Section 21 for a while, which I completely agree with this anonymous person, because obviously it was that they were elected in 2019, and so this person's wondering, how long do we have to wait realistically?
Yeah, and I see they've got a follow-up question, which again is a good one. Can we clarify this new information? So I'll try and do both. The new information is the Levelling Up Housing and Communities Committee. So this is the select committee that scrutinises the work of the Department of Levelling Up Housing and Communities. It's led by Clive Betts, a Labour MP. That committee produced a report in relation to the Renters Reform Bill. And so obviously that went to the department, the Levelling Up Department, who are responsible for the bill. The Levelling Up Department has now responded and published their response today. The quote that I gave you, I'll read it again, comes direct. I mean, I've literally I saw it on Twitter this afternoon, and just had a very, very quick look because I knew I was doing this. So I haven't read the whole report myself, but this stood out. It said the government will, this is like a bullet point, so there'll be more detail on this in the report, but the government will not commence the abolition of Section 21 until stronger possession grounds, well, that's what we talked about, but also a new court process is in place. And then anecdotally, I know that behind that is trying to speed up court processes, because the landlord lobby is really unhappy about the amount of time it takes from, putting a claim in the court to actually gaining possession of the property. So they are always banging on about that. Sometimes with reason, often because they just like to bang on about it. But we would all agree that actually the court service is in a dire state, and it does need reform, and it needs to be more efficient, because sometimes the way in which it's dysfunctional is deleterious to tenants as well. So it just needs to be a properly running justice system. How long do we have to wait? I'm sorry, I really don't know, and that's because the court system is in a dire position. The courts are crumbling. The courts, some county courts, we understand, are suffering from the RAAC thing that schools have had. There's a shortage of district judges. District judges are very, very unhappy with their working conditions. There's a whole bunch of problems with the county court system as well. And the reform programme that HNCTS had for courts has been criticised very heavily by I think by the Audit Commission, but all sorts of other bodies. So if the government wanted a way of kicking something into the long grass, then saying that it would have to wait on court reform I'm afraid that's quite some grass, I'm afraid, that they're kicking it into. It's hard to know what they mean by it, and obviously I'd like to see the report in more detail, but I am worried about this, and I suspect, Generation One will be as well. The devil will be in the detail.
Yeah. So does that mean that they would delay the bill, or they would bring the bill in, or we just don't know yet? Is that?
We just don't know. I mean, I'm not amazing on parliamentary procedure, but they could get the bill all drafted and ready to go, and then just I think you can enact it without bringing it into force. So you can have parts that are brought into force at one point, and then you delay other parts of the act because they all need commencement orders. Each part of the bill needs a commencement order to start it. I'm showing my ignorance now, parliamentary procedure, but
No, definitely not. It's complicated too.
we could. I mean, again, I don't want to be pessimistic, but we could end up with all the rubbish parts of the bill being brought into force, and Section 21's held back while they, do this court reform thing. I mean, here's what I think. There's going to be political change next year, I would have thought. I mean, even if we don't get a change of government, I think there will be political upheaval anyway. So even if the current government managed to win an election, I think that there's going to be upheaval anyway. I can't see the Renters Reform Act not being caught up in all of that turbulence of an election and all of that. So, we may be looking into. Look, don't take this from me. I'm not an expert in this kind of thing at all, but I'm worried that we're looking at 25 rather than 24 now. Just because of what's been said today, and again, please take that with a whole cellar full of salt, because I haven't even read the full report. So I'm just being controversial for clickbait, basically.
No, I think it makes a lot of sense, and also there's, you can tie your hopes to it being at a certain time, and then it keeps getting delayed. So in a way,
Yeah.
it's good to be cynical when it comes to these things, in terms of not relying on it being soon, in a way, because
Indeed,
we don't know.
Rosie. It's not. I mean, it's not in classic Conservative territory, so they were always going to have problems with their backbenchers. It always was going to, because it's not classic. It's not a classic piece of Conservative legislation. Did somebody have their hand up? I thought I saw somebody might have had their hand up. I don't know if they can put their question in the chat.
Oh yeah. For reader, I don't know whether you can put your question in the chat. Just because I'm not sure that we have the ability to.
While we're doing that, Elena is saying, yeah, probably won't be election till October 24. Yeah, I mean, I think the by-election results that we've just seen mean that the current government, I'd have thought, would want to see if they can turn things around before they get to an election. So yeah, I mean, again, what do I know about this sort of thing? But I'd have thought that they'd want to wait as long as possible, really. So yeah,
that makes sense. I was just wondering as well whether you could talk. So obviously you're from Hammersmith and Fulham Law Centre.
Yes.
And I was wondering whether you could talk about who is able to go there if they have an eviction. Obviously, I mean law centres in general.
Yes.
And if you don't have access to a law centre, what is an alternative approach that you could take if you receive an eviction notice?
Yeah, let me say a little bit more, if I may, Rosie, about what I was talking about earlier with this whole pass thing, and you put the link in there because I think it's really important. So, prior to August this year, the legal aid agency funded court duty schemes where a solicitor would turn up to court on a possession day, and if a tenant or a borrower or an occupier had a hearing on that day, they could see the court duty advisor for free. And the court duty advisor would try and negotiate with their landlord, and if a an agreement couldn't be reached, they would go to court and try and argue the case for the tenant. So I do that at my local court in Wandsworth. So it's a really amazing scheme. It can be very, very. I mean, it's a bit last minute, obviously, because you're just getting advice on the day, and court duty advised are very busy. They usually got just a couple of minutes or so to see a tenant, try and get something from the landlord. If not, rush into court and see what can be done. But it's an amazing service. So the government has expanded that. It's about the only piece of legal aid that they haven't contracted. They've expanded that to this early legal advice service. So anybody who holds a court duty contract, so my law centre, Hammersmith and Fulham Law Centre, we hold court duty contract for Wandsworth and Brentford County Court. Where I worked previously, which was a private practice firm in East London, that firm held, I think, 3 contracts in Stratford, Edmonton, and Romford. So up and down the country, pretty much every county court is covered by a court duty contract. It's only about, I think, 10 that don't have them. Either nobody's bid for them, or there's other reasons. But any organisation, either a law centre or private practice firm or shelter, runs some of the contracts. If they have a contract to deliver court duty advice, they can also deliver this early legal advice. So, and that means that, as I said before, just to reiterate, anybody who's had a notice from their landlord, and this can be a letter, it doesn't have to be a statutory notice or a formal notice. It could be a letter from the landlord saying, I'm going to get the property back, I want the property back. They can get legal advice and assistance, whatever their income. They can be a billionaire. They could be Elon Musk could walk in. Actually, he doesn't live in England or where. Jacob Rees-Mogg could walk in and say, "I've had a notice from my landlord, and I'd like some legal advice on it." And we can deliver legal advice to try and see whether there's a defence, whether the notice is defective. In cases where it's discretionary, we can try and negotiate. Well, we'll try and negotiate with the landlord, whatever, really. So it's a really amazing service. So as I said, non-means tested. That's never been done before. Legal aid was invented in 1948, and it's never not been means tested before, or social welfare law anyway. So it's a really amazing service. So how would you know who can deliver it? So who to contact? So one of the points is that any contracted firm or law centre can deliver early legal advice to anybody in the country. It doesn't have to be connected to their court. So that's the first thing. The second thing is the website that you kindly put the link up to contains, you can put your postcode in, basically, and it will tell you within a radius of, say, 10 miles or 20 miles, who the nearest early legal advice providers are. So you could go to that website and find out who would be the best person to call to see if you can access this early legal advice. It's also, so what I do in my local area is I do periodic training for local advice organisations. So again, I'm trying to kind of put that out to Citizens Advice and the Food Bank and, lots of organisations who are kind of frontline first stage advisors, so that they know that they can try and refer people to that service as well. And I'm hoping that that's sort of going on up and down the country. The government, the MOJ, have been a bit dreary about advertising it. We were hoping that they would advertise it a bit more themselves, but they're just a bit rubbish at that kind of thing. But we're trying to do that, and we're trying to get the message out that this service is available to people. Yeah, it's an amazing service. Now, the big thing to say about it is, so the government are paying us to do this work, but they've not introduced any capital for us to build up capacity in the sector. So, there were already few enough housing lawyers and you know, so the sadness about this is that there will be people who are entitled to this advice and they won't be able to get it because their local centre just doesn't have the capacity to look at their case. Again, that's something that we'll try and talk to government about over time, that if they're serious about the project, then they need to build in capacity so that we're here to deliver this advice. But you know, it is a really remarkable service that's been introduced, and yeah, any help actually that we can get in just you know, just publicising its existence is really helpful. The government web, the page that Rose has put in the chat is quite good actually. Once you've got your head around how it works, it's really good at getting you to sort of your nearest source of early legal advice on that. So, yeah.
Thank you. That's really helpful of telling us about that service. I will put it in the email as well afterwards so that everyone can look through it. And yeah, if you don't manage to grab it from the chat, then you can still access it. And yeah, just I think we're coming to a close now. We are just very grateful to have had you come and share your knowledge with us, Simon.
It's my pleasure. It really is.
Good.
I did this last year, and it was great last year as well. So it was a real pleasure to be asked back to do it again. And yeah, and anytime, always happy to talk through this stuff. And again, thank you to those who thank you to everybody coming. But those of you put bits in the chat and the Q&As, because some really interesting points in there. I'm sorry that I'm not able to sort of, you know, it's not only complicated stuff, but there's a lot of politics here. I mean, there is, whatever your political persuasion, I'm not sort of trying to press you one way or another about how you think about that, but you can just see about what's happening with the Renters Reform Act, that there's a lot of politics involved. And, you know, this is why Generation Rent is such an important organisation, because Generation Rent is really pressing through, trying to cut a swathe through all of that politics and just get to what's important for renters, because that's the most important thing here. The landlord lobby is powerful and it will always make the points that it wants to make. You know, it is very important that Generation Rent and the coalition as a whole is there to cut through all of that and really make the renters' case. So thanks for everything you do at Generation Rent and the whole coalition.
Oh, thank you. It's really great to hear that. Yeah, we'll get there. We'll carry on working in this space. And I'm really sorry. There is just one more question that's just been added in as well, and I'd hate to leave with an unanswered question. It's from Eleanor as well, who got the about Section 21 earlier, and she's just asked whether she works in Hammersmith and Fulham, and has asked whether she'd be able to make an appointment to see an advisor if necessary at the law centre. So,
Elena, we have we run a rota for general inquiries, so anybody can ring into that. It's triaged by our sort of reception staff, so you won't get a legal answer straight away. But what happens is that they get the details, and then it comes through to the advisors to get back. And you know, we like to think that we get back pretty quickly. You know, 2 or 3 days at most, or if it's urgent, even quicker. So, Elena, if you want to ring in, make sure you leave your name, because it'll even with my feeble brain, it will I'll remember. Or if you want, if it's for you, that's amazing. If it's for somebody you know, they can ring in as well. But anyway, they can ring in, and it will get through to one of the advisors, and we will call them and talk to you about it, and see what the next steps are and what we're going to do to help you.
Brilliant. Thank you so much.
I haven't got our number to hand. I've only worked there a year and a half, and I can't even remember our switchboard number, because it's not one of those, you know, 9,000 or 1,000 type numbers. But Elena, I'm sure our number is very easy to get hold of. So
we can share. in the
Yeah.
email as well, any information. So yeah, thank you.
Right, and I look forward to speaking to you soon, Elena.
Brilliant. Well, thank you so much. And yeah, I hope it's Friday night, so we'll tie it up now and let everyone enjoy the weekend. But yeah, I just 1 second. Let me just share my screen because we have got some ways as well to get involved with Generation Rent and to sort of join the campaigning for renter reform. So I'll just quickly go through these and then, yeah, I hope you all have a lovely evening and thank you so much for joining us today. So 5 ways to help. Number 1 is to stay in touch and just, yeah, join onto our email list. Like we will be sending out regular ways to get involved. And it's just a useful way to keep up with some of the things that Simon was touching on today in terms of the politics and the legislative side, the mixture and kind of Generation Rent. We'll keep you up to date on that. And another way is to share your experience as well. So obviously a huge part of making sure that reform happens is making sure that it happens for renters from their experiences and not to renters. So the more that people are sharing their stories, the better that we can make sure that the narrative is led by people who have first-hand experience. We also, there's ways to get involved with our research as well. And to help us campaign through volunteering and things. And we also currently do have a crowdfunder, which you can join. And we have a great selection of books that some authors who've written on housing have kindly donated to help with, yeah, Generation Rent. And so those are some ways to get involved. But yeah, please stay in touch. And thank you so much for joining us on Friday evening. And big thanks to Simon as well. We really appreciate it. So yeah. Bye.
Thanks, everybody. Have a great weekend. Bye.
Thank you.